for your work in preparing this case. I think this matter, we've got half a day. We think that ought to be sufficient to deal with the relatively limited issues. Before we get started, my lord has an observation to make about one aspect of the case.
Not the question of the extension of time, which you're going to argue fully, but whether it's correct for the Secretary to take the view that this was paragraph 41C, not 41A, that this was not a custodial sentence. I appreciate that's in her guidance, and I appreciate that's what is in her decision letter. But one does wonder whether she's correct, because if you go to the former Criminal Justice Act provisions and the current Sentencing Act provisions, a sentence of imprisonment is a custodial sentence. It is a custodial sentence. A suspended sentence order is an order that a custodial sentence does not take effect. And if there was any doubt about that, the guidelines, Court Imposition of Community and Custodial Sentences, has a very interesting sentence. A suspended sentence is a custodial sentence. And the point is the sentence of imprisonment is not activated. If you break the law again or break the terms of the suspended sentence order, the sentence is activated, but it doesn't start as custodial, become non-custodial and switch back. And that rather undermine your point, but it's not a point that the Secretary of State has taken, and it's contrary to her guidance.
That's right, my lord. With those observations in mind, we will double check the position. I think the answer is in section 117, part 5A of the 2002 Act. Unfortunately, my laptop is causing me real difficulties because, frankly,
I haven't got that with me actually, but
so I'm just going to say, logistically, I'm going to have difficulty referring you to that because my laptop is.
Yeah, but can you at least give us a hint again of what this, what you say is part? You said the 2002 Act, the National Immigration Asylum Act.
There are definitions in section 117D.
Right.
And I need to just remind myself of those.
What have we got? What have we got in our authorities bundle?
Which section did you say? I'm sorry.
Section 117, capital D, my lord.
Oh, you can't read it out because you haven't got it. I haven't got my laptop with me. But don't worry, if there's an answer in that section, and that defines custodial sentence.
It defines a sentence. I'm very much running on memory.
Sorry, yeah.
So I think that's the answer. I apologise.
What do you think it says, Mr. Biggs?
I think it specifically refers to imprisonment excluding a suspended sentence.
Oh, right, so we'll have to have a look then.
So we will need to look at that provision.
Right. That's not the relevant paragraph that we're dealing with, though, is it?
No, it's not.
We're dealing with paragraph 9 or
we're dealing with, yes, we're dealing with the immigration rules.
yeah.
The Secretary of State's position is that those immigration rules should be interpreted in line with the scheme under Part 5A, but I appreciate that the scheme under Part 5A is dealing with something different.
Yeah,
it's dealing with
because the general rules deal with all things, and they refer to criminal offences and suspended sentences.
Yes, but my lord, you're quite right. The guidance takes the position that we've taken in the respondent's statement, and on that basis, point in this case, whether in another case we might want to is another matter in light of our laws.
Do you want us to look this up? This section, just which section? Remind me which act and which section?
Section 117, capital D of the Nationality, Immigration and Asylum Act 2002.
Yeah.
But I appreciate that, as my lord puts to me, that's not directly in effect relevant, but it does it's set up, if you like, a background to the provisions within Part 9 of the immigration rules, which are intended to.
Well, that's not correct, is it? Because Part 9 was there long before the foreign criminals issue. Part 9 and criminal offences hasn't that been there before that?
It has, but it's been amended on various occasions.
Yes, I know, but it's not right to say it was done to implement that. It exists.
No, I didn't mean to say it was meant to implement.
You may not be a foreign criminal, and you may not have to be the subject of a deportation order and all those other things.
Yes.
But that's not the same as saying you can't be refused leave if you commit a criminal offence.
Section 117D.
Subsection 4A, my lord.
4A, or 4, in this part, references to a person who has been sentenced to a period of imprisonment of a certain length of time, A, do not include a person who has received a suspended sentence unless a court subsequently ordered the sentence or any part of it, or whatever is to take effect.
So that's the basis for the position that's been taken in policy and the position we've taken in this litigation.
It does say in this part, and we're dealing with part 9 of the immigration rules. That's the only part.
I acknowledge that, my lord.
Yeah.
But as my lord puts to me, the policy position is consistent with that definition, albeit that we're dealing with a different context.
Anyway, we may never get there.
Thank you.
Well, we've taken that, we wanted to raise that point to start off with, but that's not the focus of the principal focus of the appeal.
My lords, no, perhaps I can make do with introductions, given my lords have introduced us in any event. So,
Well,
perhaps-
you're well known in this court.
I'm grateful. Mr. Jamali also appeared on behalf of the appellant.
And so is he.
Not to introduce him. My lords, just in terms of papers, if I may,
Yeah.
we have a core bundle of 1 to 7.
Yes.
A supplementary bundle of 54, the initial authorities bundle of 294, and then a short supplementary bundle of authorities of 101. Now, with that in mind, in terms of order of business, largely led by Lord Justice Warby's order of 2025, the manner in which I propose to deal with the issues is to first of all make the application for an extension of time for, or relief from sanctions, I should say, in respect of the appellant's notice that was filed 3 days
Okay.
after the
Yes.
required period. Then to deal with what I think should be a short application to amend the appellant's notice of appeal, and finally to then address the court on the 2 grounds as advanced. I assume, although I may be wrong to do so, that the court will proceed to hear all 3 in sequence, depending essay.
Let's see how we go.
Very well, my lord.
So you
with
can
that-
take it that we think we've read the key documents in the case, and we think we're on top of the issues, but
My lord, may I then
Well, we
skip
like
through the
this.
facts and go straight to the application to extend time or for action?
do you want to in a sentence, just I think for the record, as we're in open court, just in a sentence or a paragraph, explain what this case is about, why we're here.
So this case relates to an individual who came to the UK in February 2022 as a student. Shortly after being in the UK, he was convicted on the 23rd of January 2023 for arranging and facilitating the commission of a sexual activity with a minor.
How old was he at the time?
I beg your pardon.
How old was he at the time?
I must remind myself of that, my lord. Relatively young, I think, but nonetheless an adult himself. So born in 1997, and at the time the offence took place, that would have made him, on my very poor maths, 26 years old. That's rather embarrassing to start to the hearing, I apologise.
An adult.
Now, at 26 years old, the conviction led to a sentence of 17 months imprisonment. As my lords are aware, that was suspended for a period of 2 years. And the Sexual Harm Prevention Order under Section 103A of the Sexual Offences Act 2003. The natural progression in many of these cases for students would have been to apply for leave to remain as a graduate. That was refused on the 4th of January 2024. As my lords are aware, the Secretary of State relied solely on paragraph 9.4.1c, not on A and not on B, which deals with assistant offenders. As a consequence of that refusal, the second appellant, who is the first appellant's wife, also failed to be refused. And on the 22nd of February 2024, those decisions were maintained at the administrative review stage.
Do we know anything about the facts of the offence, since there's an issue about the nature of the harm? Was it, well, do we know how the sentencing remarks, for example?
We have limited snippets of the sentencing remarks contained in the Secretary of State's acknowledgement of service to the judicial review claim. And what we do know before we turn those up, my lord, is that there wasn't, in fact, contact with an actual minor child. It is a fortunate fact of this case that the only contact that's recorded is in fact contact with an undercover police officer, and so no contact with the child was made. Regrettably, as I said in the original grounds of review, the appellants don't have access to the sentencing remarks. The little information that is provided is then contained within the Secretary of State's summary grounds of defence, which are at tab 14 of the core bundle. I'm so sorry, it's 115 that we're looking at, my lord, and it's paragraph 16.
Yes.
And that is as far as we go. But the key factor of this case, which was pushed upon before the Upper Tribunal when permission for judicial review was sought was that this, of course, did not involve a child that was in fact contact, unbeknown to the appellant, with an undercover police officer, or as it's termed in the papers, a decoy child. A challenge to that final decision of the 22nd of February 2024 needed to be made by the 22nd of May. It wasn't, and as Upper Tribunal Judge Sheridan noted, permission for judicial review wasn't sought until 7 days after the 3-month-long stop, which of course stops at being on the 29th of May 2024. Judge Sheridan finally refused permission for judicial review following a reconsideration hearing. That hearing took place on the 31st of January 2025, and an extempore judgment was given on the same day.
Yeah.
The order was then sealed on the 3rd of February 2025 and communicated with the parties on the same day. The parties or the appellants accept that permission to appeal to this court should in those circumstances have been filed by the 7th of February, but the appellant's notice went in on the 10th of February 2025.
You say by 7, do you mean on the 6th or by 4 p.m. on the 7th?
By 4 p.m. on the 7th.
So, and he went in, just remind me, on
On the 10th of February.
What days of the week were they?
I was about to come on to that in the event because they are important. So the 7th, which would have been the deadline, was a Friday.
Oh, so I assumed you were going to make that point.
So
So the 10th was the next working day.
it was indeed the next working day, the Monday that followed. Having filed an appellant's notice on the 10th, on the 24th of February 2025, on the anniversary of this hearing, the appellants filed a skeleton argument, which was a skeleton argument I drafted, and with that, amended grounds of appeal. The appellant's notice itself was then issued, to understand it, on the 26th of February, with Lord Justice Warby making his order on the 17th of July.
Yep.
So those are the underlying facts.
Thank you.
That lead us to the first order of business, which is the application for relief from sanctions. Of course, in those circumstances, we are applying Denton. The first and foremost point to make is to consider whether the delay or breach in this case was serious and significant. The appellants make the point of saying that it wasn't. The deadline, as my lords have heard, was a Friday, the 7th of February, and the appellant's notice was filed the next working day on Monday the 10th. Calendar days, that gives the appellants a 3-day breach. On a working day basis, it was done on the next working day. In those circumstances, especially when considering, albeit I accept not relevant for the purposes of the rule, that the order of the judge was sent out on the 3rd of February, the court is invited to find that this is a case in which the delay was not serious and significant.
what's the explanation for the delay?
The explanation for the delay is set out in a witness statement filed by Ms. Carr. The short point that's made, and I'll take my lord to it. So this is behind tab 4 and page 47. As my lord will see from paragraph 2, the order was received on the 3rd of February 2025, an email to the first appellant the next working day. Understandably, I would say they had questions. Firstly, in respect of the hearing, and secondly, in respect of the costs of an onward appeal, and wanted to attend the office. Mr. Jamali.
So the hearing been on the 31st, and the extemporary hearing was on, the extemporary judgment was on the 31st. Were the appellants in court on the 31st?
No, ma'am. Mr. Pullinger represented the appellants on that occasion, but I understand that the appellants were not themselves in
Right.
court. And the 31st would, from my calculations, also have in itself been a Friday. The
What I don't understand at the moment is, since everyone knew the hearing, the outcome on the 31st, why did the sisters wait until after the 3rd to tell them the outcome of the hearing, or did they tell them the outcome of the hearing after the 31st?
May I take instructions on that? What I'm told very cautiously is that we can't be certain that they were, but it's likely that they would have been told on the same day the hearing took place, on the 31st.
But if you're applying for an extension of time, you've got to tell us the facts. And we don't know whether or not the solicitor must, I mean, somebody on your side must have known on the 31st of January that the application had been refused. What
May
we
I
don't know at the moment, you've no evidence as to what happened between the 31st of January and the 4th of February.
May I just turn my
Yep.
back on? It may perhaps, just to ensure we stick to the half-day listing, my lord, be a matter I'll come back to
Yeah.
whilst those behind me make inquiries. If it transpires that the appellants were not notified until the 4th of February, which is the date on which the email was sent, and that is, in my submission, a relevant factor when it comes to the third limb of the Denton test, looking at all of the circumstances. The 4th of February would have given the appellants very little time, and understandably, in my submission, they wanted to see their representatives and to gain an understanding of what the procedure
The next
enforced.
problem is, a no disrespect your junior, given the time is going to expire, if he's not available, they've got to do something, even if they've got questions. There's the second period of unexplained delay, is that between the 4th and the 10th, when they knew the time, when the solicitors knew the time limits were passing, nothing was done.
Can I perhaps step back, my lord, and answer it in this way? In my view, the force of the appellant's case in respect of the application for relief from sanctions lies in the first limb, which is the short period. Now, that, of course, doesn't mean that the court isn't required to consider the other limbs, but equally the force lies in the other circumstances of the case, which is the third limb. The facts as presented, which are the email being sent on the 4th of February, Mr. Jamali not being available until the 10th of February for a meeting as requested, and even if that's not correct, and in fact notice was given on or around the 31st of January.
Well, they should have been told, Mr. Jamali is not available, we'll have to contact somebody else because the time limit is passing. But you clearly should have dealt with all of this in the witness statement because you're applying for it and it's the obligation of the solicitor to tell us everything that happened.
Well, without perhaps making a formal concession in respect to whether or not there are good reasons, the focus of my submissions in reality is on the first and third limbs of the Denton test. Now, if I may in those circumstances address the court in respect of all the circumstances of the case,
Yes.
the appellant's position in those circumstances includes a number of factors. The first, which is, I accept a double-edged sword in some respects, is the relatively short period of time between the extempore judgment being given on Friday, 31st of January 2025, and the deadline within which an appeal needed to be filed. The issue is somewhat more complicated than perhaps would be in an ordinary case, in the sense that the judge put forward reasons outside of the grounds originally pleaded, which dealt with the refusal to admit the application and did so by applying the high Sach test. My overarching point starts off, nonetheless, by identifying that there appears to have been no prejudice in this case to the Secretary of State by what we say was a short breach.
There's prejudice to the public interest. If there were prejudice, that would be a powerful factor for refusing it.
Indeed.
But if you have to establish as the respondent prejudice, you'll virtually never be able to do that, and that's not what the rules in the case law say.
My lord, I agree. Now, in terms of prejudice to the public, whilst I accept the weight to be attached to good administration, what we don't have in this case is factors that go against the appellants in this application to extend time are, for example, removal directions having been set, where removal directions would have needed to be cancelled. That would come at a significant cost to the public. We see in other cases, in particular when one looks at planning judicial reviews, the significant public interest that is identifiable and to a degree quantifiable by late challenges, especially when there have been expensive reliances, often by public parties, on the belief that they can proceed on the premise of there being finality. But overall, whilst I don't wish to undermine the weight to be attached to prejudice on the public, in this case, the appellants would submit that it is difficult to identify it, and given the short delay, it is a relatively de minimis prejudice, if any. By contrast, the position as things stand is that the prejudice to the appellants, if permission is not granted or if relief from sanctions isn't granted, would be substantial. The first appellant, and I make this point both in my application for relief from sanctions and substantively, is not, in light of his criminal activity, worthy of a great deal of sympathy. The second appellant, however, is insofar as we understand it an entirely innocent party. The issues in this case have warranted Lord Justice Warby directing that this matter be listed for a rolled-up hearing. And this case raises an important issue within the confines of what's been pleaded, and I say that to respectfully exclude the earlier observations in respect to the custodial sentences, but within the confines of what is being pleaded, to the application and interpretation of paragraph 9.4.1 of the immigration laws as things stood at the time. Both the interpretation and application by the Secretary of State and subsequently Judge Sheridan's decision that, despite acknowledging an arguable case, that no actual harm had been identified by the Secretary of State, that this was a case in which the appellant's conduct was harmful to the community. So we have an important issue to be tried, no identifiable prejudice either to the Secretary of State herself or to the public in this case, a comparably significant prejudice to the appellants if the short extension or relief isn't granted. And perhaps if I can just turn my back to see if I do have an answer to my Lord's questions. I'm afraid I don't have an answer. Now, without an answer, I would invite the court to proceed on the basis that it would appear from the wording that's used in the witness statement that the first notification given to the appellants was indeed on the 4th of February.
Okay.
If that is right, then in my submission, that is a further factor in their favour because they cannot be held to fault.
No, but it doesn't matter. They've got solicitors conducting this, and normally errors on the part of solicitors don't justify an extension of time. Otherwise, they could come back 6 months later and say, well, they never told us this.
My Lord, I agree, and I can see cases in which the force in that is capable of being significant. And there are, and I say this without prejudice to any position taken by the appellant solicitors, there are avenues open to those who have, in cases, been poorly represented. They are not avenues that assist in this sort of case because damages are not an adequate remedy to.
I'm more trouble that they haven't told us this in the witness statement. They should have explained everything. Anyway, they haven't, and we can only proceed on the evidence.
Have we covered everything we need to on this preliminary issue?
Unless the court has any questions, I
I don't think we do. We're not going to give a decision on this now. We'll roll it all up with our final decision in due course.
I'm very grateful, my Lord. The second of the three orders of business is then the application to amend. That application in reality relates to inviting the court to substitute the old grounds of appeal for the new. And before I take you to the two documents in question, the court is invited to find that insofar as case management directions are concerned, this is a case in which the amendments are relatively minor. They are designed to assist the court. And in my submission, do not change the overall picture of what the appellants were arguing. So the original grounds are at tab 10 of the court manual, which is at page 89. 2 points were taken. This is paragraphs 2.1 and 2.2. The first was to say that the judge irrationally refused to admit the application of the claim despite the claimant's ground being confirmed as being arguable, as he said at paragraph 11 of his order. And the second, at paragraph 2.2, was to say that it was procedurally unfair for the judge to refuse to extend time. So that's the original document as filed. By comparison, at pages 87 and 88, tab 9, we have the proposed amended grounds of appeal, signed off on the 22nd of February. Tab 9.
Tab 9, 87, yeah.
And the amended grounds are at paragraph 5. 5.1 says that the judge irrationally concluded that the case was arguable but not particularly strong, and drew back in from the original grounds of review the reliance on paragraph 9.4.1, and properly particularised that the judge's reliance on the offence having contributed to a widespread problem was in this case perverse. The second of the two grounds, in my submission, does very little, if anything, other than to change what was originally said, which was that it was procedurally unfair for the judge to refuse to extend time.
So you're saying paragraph 5.2 of the amended grounds are to all intent the same as 2.2 of the original grounds?
Save for changing procedural unfairness to irrationality. So paragraph 2.2 is amended so as to effectively give it its proper label, moving away from procedural
Is there any
unfairness.
difference between 5.1 and 5.2? 5.1 looks as he concluded irrationally that it was arguable but not particularly strong, and 5.2 is irrationally refused to admit, and the irrationality is looking to see whether it was arguable but not strong. Aren't they one ground in the same way, in different ways, or is there something bit different about them?
It's difficult to resist that, and at best they are two sides of the same coin. Now, my lords, the overarching submission that the appellants would make in those circumstances that this was not a major overhaul of the grounds as originally pleaded. It was, to a degree, a cosmetic exercise of providing a proper label and more detail to assist the judge deciding the application on the papers. And at best, it was an elaboration or crystallisation of the grounds as originally pleaded. Now, the Secretary of State, and I'm content to stop my submissions on this point if the court feels it's not required, but the Secretary of State places reliance on this court's decision, a relatively recent decision in the authorities bundle of the case of Beebe. If it's required, that's at tab 6 of the original authorities bundle. The facts are not vastly relevant, but insofar as they would assist the court, Mrs. Beebe had applied for leave to enter as a visitor. That application had been refused by the entry clearance officer. The judicial review had been unsuccessful with an attempt to, and these are my words, not court appeals, effectively through the door, put in a ground of review that hadn't been originally pleaded, and that had been done in the absence of a formal application. The Court of Appeal, in particular the judgment of later Justice Andrews, felt compelled to express its understandable frustration at the actions of those representing the appellants in, first of all, seeking to rely upon a ground of appeal and a public law argument that had never properly been pleaded before the Upper Tribunal, and then 6 weeks before the substantive hearing in this court, seeking to introduce, looking at paragraph 3 of later Justice Andrews' judgment, what was termed as a replacement skeleton argument, but what her ladyship said was a document that sought to completely recast the grounds of appeal in terms for which permission had never been sought or obtained. I understand the Secretary of State's attraction to BB, but in my submission with the greatest respect, it is misplaced in this case. BB involved an entirely different factual scenario, not the cosmetic amendments that have been made to the grounds of appeal as the court sees here, and an entirely different chronology. The amendments in this case were made promptly, filed on the 24th of February, so within 14 days of the appellant's notice having been filed. Well before any decision had been made by this court, of course we don't have a grant of permission and this is a rolled up hearing, but the prejudice to the Secretary of State in those circumstances of the amendments that have been put forward on 24th of February are in my submission, with the greatest of respect, and I hope I don't overrate the pudding, non-existent, especially when my learned friend has had the opportunity to respond to the grounds as amended. So those are my submissions in respectively the second order of business.
Yes, well, again, we're not going to endeavour to have a ruling on that point at this stage. We'll hear submissions on everything and draw it all up in our final decision. Thank you.
My Lord, I'm grateful. Now, in respect of the substance and why the appellants say that both permission to appeal should be granted and indeed this appeal should be allowed, is the
Hold on.
overarching
You
point.
need to check what we're dealing with, because we're only dealing with the appeal, which is whether or not the judge was wrong to refuse to extend time. We're not dealing with the underlying case, are we?
No, I appreciate
okay,
that.
yeah.
I appreciate that entirely,
Yeah.
my Lord. I'm conscious of the difference in powers between judicial review that comes up from the administrative court and the Upper Tribunal. But with that in mind, Judge Sheridan's order is at tab 11 of the bundle, page 91 of the core bundle. And the key target is paragraph 11. Now, paragraph 11 is one in which the judge, having found earlier within his order that there had been a serious and significant breach of filing the judicial review claim 7 days after the 3-month.
Well, it's promptly is the test, actually, and in any event,
Indeed.
3 months. So it's not 7 days late, it's many days late, and it's even outside the absolute outer limit.
My Lord, yes, I accept that, and there's no contest from the appellant in respect of that entirely correct proposition. Having found that there was a serious and significant breach.
I mean, you don't disagree with this, well, you haven't challenged the assessment on 1,
No.
the significance, the assessment on 2, the reasons for the delay are not good. So we're into 3, all the circumstances of the case.
My Lord, yes, and that's dealt with from paragraph 9 of the order, but for the purposes of my submissions, it's paragraph 11 that I'll focus on.
But you have to get over 10 first. I mean, Highsouch does say that when we're dealing with delay, you can't circumvent the whole substratum of rules, which says, look, these things are important. There's a public time to challenge, interest in challenging these within time. There are stacks of authorities to that effect. You've got not one, but a number of cases in the Court of Appeal saying you've got to apply those rules rigidly, and that normally you don't look at the merits, because what you're looking at is the rules. But if we just look at the merits, we may as well not bother with stage 1 and 2.
Well, my Lord, insofar as the merits are concerned, we can see from paragraph 11 that the judge does hear submissions on the substance, and he does so in order to assist him with the question of whether or not to extend time. And the reason I focus on 11 for the moment, and I'll come back to the propositions made at 10 in due course, is my submission is this. Lord Justice Warby in his order has asked the question of whether we're dealing in the context of a judicial review claim with an extension of time or release of sanctions. The appellant's overarching proposition to that is that Maharaj and other authorities would indicate that it's an extension of time and not an application for relief
But
from
there's
sanctions.
3 cases in the Court of Appeal that say it's not an application for relief from sanctions.
Indeed.
But the same approach should be taken towards it. So we are not dealing with relief from essential sanctions unless there's a difference between filing the application for judicial review and filing an application to reconsider, because Keegan says it's the principles underlying things. So it's not a discussion anymore about is it Denton or is it something different. It's something different, but applying the approach.
Well, my lord, with that in mind, it seems that the appellant and the court are aligned in respect of that issue. So I will be able to address you on that relatively succinctly.
Yeah.
But the appellant's overlying position is, regardless of that debate, even if there were one, in circumstances where Upper Tribunal Judge Sheridan has relied upon the alleged harm to the community in order to observe that this was not a particularly strong case and to refuse to extend time. Those 2 points are so closely interlinked that they are inseparable insofar as the judge's order and reasoning are concerned. The effect of that in my submission would be that if this court concludes that the Upper Tribunal erred in concluding that this was a case involving harm to society as a whole within the confines of the Secretary of State's guidance, that error infects the judge's decision and reasoning for refusing to extend time, because in my submission, the two cannot be separated given the manner and the very...
In order to know that, even if it is a 941, if it's a 941A case, that's the end of it, but Secretary of State says, no, it's not a 941 case. If it's a 941C, we've got to have arguments then about whether or not it was harm. We'd need to know what the circumstances were. We don't know whether the child wasn't there. It's unlikely to be the case because the policeman saw what was happening and intervened. Or whether it was one of those cases where the website that was set up, the man thought he was going to have sex with the child, but fortunately it was the police officer. I mean, how can we look at any of that in the absence of evidence? And if we do look at it, then we're really deciding the case. And what's the point of the rules?
Well, my lord, insofar as the detail is concerned, perhaps the most helpful document is in the supplementary bundle. And it's the 7th tab. I apologise, it is a poor copy.
Sorry, again, I don't have tabs, so the page one.
I'm so sorry, my lord, it's page 44 of the supplementary bundle.
My tabs aren't numbered, so can you give us page numbers as well?
Of course, my lord, I'm so sorry. It's page 44.
That's a letter from Ellen Moore Solicitors.
That's correct. Now, this provides a degree of assistance, and again, as I say, I apologise that this is difficult to read. The judge's sentencing remarks are from page 45. And at the bottom they read, whilst living in Crawley, you responded to an advert.
Well, would you like us to read the whole?
I'd be grateful, my lord.
So, should we read the whole thing from sentencing remarks? Is that what you'd like us to read?
I'd be assisted if the court... Oh, my lord, yes, thank you.
Right. Do sit down while we do that.
Thank you.
if you're
Yes.
sitting in the CACD, you'd be quite concerned that it is persistent. There were a number of phone calls, 2 phone calls, a number of messages. He actually attended at the site and he had the money to pay for it. It wasn't just inquiries on the website. He's gone looking for a child, willing to pay for it and able to pay for it.
All of those facts are borne out by the sentencing remarks, my lord. Yes, I accept that. This appeal does not seek to justify his actions
No.
or to minimise his actions, but simply raises an important point where an individual is entitled to have their case decided in line with the immigration rules and the guidance in play. Whether the Secretary of State has properly decided that, but of course for the consequence of this appeal, whether the judge was wrong to refuse permission, despite acknowledging that on the case conceded, that was arguable. Now,
So what's the? We know from paragraph 10 of the judge's reason, which you're going to come back to, that generally speaking, the merits are not relevant. When do you say they are relevant, and why do you say that threshold is crossed here?
they become relevant, albeit with caution, in respect to the third limb of the Denton test, all the circumstances of the case. The threshold we say is crossed here by reference to.
Sorry, they become relevant to the third limb when? So, for example, does it have to be shown that the merits are overwhelming before they become relevant to this extension of time question?
I think the terminology that's used in hindsight, which maybe we set out in the order, is a very strong case. Going back to the judge's order in question.
Because we haven't even got, I don't know if there was a pre-sentencing report, there often is a pre-sentencing report, and there you have actual assessment of harm and so on. Do we know if there's a pre-sentence report?
Not that I've been made aware of, my lord. Now,
Do you know there hasn't been one, or do you just not know whether or not?
I'll check if I may. We don't have instructions on a pre-sentencing report, and the sentencing remarks themselves.
It's not referred to, but we don't know. I mean, the problem is we haven't got the transcript of the sentencing remarks, which would have been available. We haven't got the pre-sentence report, if there was one, which would have set it out. If you're not going to have a pre-sentence report, and it's very unusual not to have a pre-sentence report if you're thinking of suspending a sentence, because you need the sentencing, the probation people to tell you what community requirements, such as supervision, work in the community, other forms of work like sexual treatment, attendance, and so on. So there's quite a lot we don't know about the merits of this case, or there's quite a lot we might not know. But you say, to go back to my lord asked when the merits were relevant, and you said in the circumstances set out in High Sash.
So in hindsight, just looking at the extract that's relied on at page 92 of the core bundle, paragraph 10 of Judge Sheridan's order, refers to a heightened consideration, so very strong or very weak.
So what's said, in fact, is only in those cases where the court can see, without much investigation, that the grounds of appeal are either very strong or very weak, will the merits have a significant part to play?
Yes, my lord. Now, with that in mind, and with the caveat that my lord reads out in respect of the absence of much investigation, the court is invited to proceed on the basis that paragraph 11 of the Upper Tribunal's order is the product of that assessment without much investigation. As the court is aware, at paragraph 11, the judge began by saying that he heard submissions on the substance of the application in order to assist in resolving the question of whether to extend time. That does not suggest, on first reading, that this is in fact a case in which the judge has gone beyond what HISAJ says is required, which is a first investigation.
So
The reason we say that, sorry,
Just talk us through how you're interpreting paragraph 11 in the context of HISAJ.
paragraph 11, as I understand it, is an observation made by the Upper Tribunal that this is an arguable case, but not a very strong one, because even though it could be argued that the applicant didn't harm anyone, having only ever interacted with an undercover police officer, the guidance allows for harm to society as a whole. And that's where we say the error applies, because the guidance hasn't been properly considered and applied by the judge.
Well, the crucial words, his case is not a particularly strong one. And then the last sentence, as the grounds are arguable but not strong, my view as to the merits does not lead me to conclude it's appropriate to grant an extension of time. Isn't he there applying high sage as, well, the key part of high sage, which my Lord Justice Zacaroli just reminded us about?
My lord, yes, and that's accepted by the appellants at this stage. The difficulty that we say with this order in paragraph 11 in particular is that the underlying reasons identified in paragraph 11 as to why this was arguable but not strong are incorrect.
What do you mean by that?
And
You disagree with them, or there's some legal error?
I beg your pardon.
You disagree with them, or there's some legal error?
The appellants go as far as to say, as to grounds, that there was a degree of irrationality within the conclusion that has been reached. Now, in order for me to make that good, it is important for us to understand both the context of the rule itself and the wording that's used in the guidance. So perhaps now's a good time to look at that. Now, within the original authorities bundle at page 12, at the bottom of that page we have paragraph 9.4.1, which identifies the three grounds upon which an application for permission to stay must be refused.
Can we just orientate ourselves into this? I know what the respondent is saying about his view of policy, and we had that argument in a recent case. But these are the immigration rules. It's part 9. It applies across the board to those parts of the rules that say you will not get your leave, whether it's students or families, if you fall for refusal under part 9. That's what they normally say. And then there are the grounds of refusal that are set out. And then if you look at 9.9.1, it says certain things this part doesn't apply to, family members and so on. You go through all of that. Ukrainians are exempted. Then it tells you what it does apply. Then section 2 is grounds for refusal of entry, clearance, permission to enter. So it's not just deportation for foreign criminals, it's everything. And then you get down to criminality grounds. And an application for entry, clearance, permission to enter or permission to stay must be refused. And was this an application for leave to remain?
It was for leave to stay or leave to remain, my lord. The terms are used interchangeably.
And that applies where he's been convicted of a criminal offence in the United Kingdom. Well, that's happened here, for which they received a custodial sentence. Well, that depends on whether or not it comes within that. And I heard him say and then entry clearance must be cancelled when he's being convicted of a criminal offence for which they received a custodial sentence of 12 months or more, but we're not in that, according to Mr. Biggs, is persistent or has committed criminal offences which cause serious harm. It would be useful after the hearing if you could confirm, both of you, whether or not paragraph or section 9 was in that form before 116 of the 2002 Act was ever applied. There will have been changes, but whether or not there was an essential criminality ground even before 2002 and whether it was in the same terms.
It shouldn't, my lord, be difficult to put forward.
It should be, you just go to the archive section, it's just tedious. Anyway, sorry, yes. So you're on 9.4.1C.
My lord, yes, I'm grateful. Now the language of the rule, which of course we know is to be construed sensibly with reference to the words used, has committed a criminal offence, or we can tick that, which has caused serious harm. So it's a reference to past tense, and as the authorities, which I accept deal with the 117 provisions as opposed to 9.4.1, will identify in a moment, and I'll take the court through them, doesn't involve intended harm, but is pointed towards actual harm. And the point as argued before the judge in the Upper Tribunal on the papers was that given, for want of a better word, the fortunate circumstances of this case, no actual harm came about.
No harm came about to an individual child, but you've got a network of people offering child sex services, and there's a market for them, and he's tapping into that market, or trying to, and it's arranging or facilitating.
My lord, I'll come back to that if I may. Now, insofar as the rule is concerned, it is past tense, and as I say, the authorities will demonstrate, and the judge doesn't appear to dispute that no actual harm comes about to a victim in this case because of the absence of a minor that was affected. And I say that's a fortunate element of this case for all parties involved. The position, just to deal with our earlier discussions, I don't want to bring the court back to this part of the bundle unless necessary, in respect of custodial sentences and the exclusion of suspended sentences from within that, is not only part of section 117d4, but is also part of the definitions within the...
Before we leave that, if the child turned up, but then said, no, I've changed my mind and left, there's no harm.
There's every possibility in those circumstances, my lord, of there having been some harm.
But if there wasn't, if he turned up and said, I've changed my mind, you're not the kind of punter I'm looking for. I've been around the block a lot here, just don't like the look of you, mate. No harm there.
I'm respectfully hesitant to answer that question, purely on the basis that a number of actual scenarios would have to be taken into account. The interactions that have led to that meeting in particular, which, with respect to my lord, on a hypothetical scenario, it's difficult to answer. But on the facts of this case, as my lord has heard.
Attempted murder, you shoot and you miss. No harm, the chap wasn't even looking, he was looking in a shop window.
Again, my lord, an example that may well justify the Secretary of State taking action under different provisions. The 1971 Act, as we're all aware, contains provisions allowing deportation on conducive grounds, even in the absence of a sentence that goes up to 12 months. But we are dealing here with, as I say, with all respect, a decoy child, undercover officers, and reliance on serious harm. So, just if I may, to go back to that point and my reference to paragraph 6. Now, paragraph 6 of the immigration laws contains a whole list of definitions. And at page 9 of the authorities bundle.
Page 9.
I'm grateful, my lord, page 9, thank you. Much in the same way, so this is 2/3 of the way down the page, you have to bold custodial sentence means a period of imprisonment not including a suspended sentence.
Yeah, the problem, this is taken out of context. I don't know what this document is. I see top right hand corner guidance. I don't have anything else about this guidance, do I? Or do we have the guidance?
This isn't guidance, my lord. It's the website itself is perhaps slightly unhelpful. This is an extract from paragraph 6 of the immigration rules themselves. I think my learned friend nods in agreement. Now, as I say, paragraph 6 is...
So what does... And do you mean part 6 or paragraph 6?
Paragraph 6.
Right.
Paragraph 6 is all applying. It applies to all aspects of the immigration laws and contains generic definitions in the absence, of course, of a definition contained elsewhere. And custodial sentences is defined within that.
So this paragraph, if it is part of the rules and if it's not guidance, and I just haven't got feeling Gillespie with me, the rules themselves now define. So that we don't need to get to section 116D, if you're right, this is part of the rules, and this defines the rules, does it?
Yes, I hope my lords will forgive me. When I was asked questions about this earlier, my laptop had just failed, so I was a bit disoriented. The short answer to my lord's question earlier is that we have a specific definition
In the
of
immigration
custodial
rules.
sentence in paragraph 6.2 of the immigration rules, which, as my learned friend rightly points out, is part of the immigration rules.
So what we're looking at on this single page is just a single page from paragraph 6.2, notwithstanding the fact that my copy says guidance,
Yeah.
introduction guidance at the top.
Yes, so this is
So if I go online, I'm sure you're right, Mr. Biggs, but just so I
that's right.
satisfy my own neurotic curiosity,
I
and
only-
just check that if I go to find immigration rules online,
The
yep,
first time I didn't bring Feeling Gillespie for an immigration case because
it's the first time my laptop has failed in the court.
Feeling Gillespie is the one that's got.
I know. Do you want to ask the clerk to bring it in?
Yes, actually, that might be helpful. It's
Well,
on my
my
desk.
clerk's not there, so shall I ask?
Or actually, I might ask my judicial assistant if he doesn't mind running up to my room and Feeling Gillespie's on the desk. You know it is the green book. Yeah.
You always bring that.
I always do, yeah. It's unfortunate that this has not been set out, actually, that there's a lot of things here, a lot of cases that aren't referred to, relevant provisions of guidance or rules that aren't referred to.
Well, my
It's
lord,
disappointing.
my lord, paragraph 8 of the respondent's statement on page 21.
Let's have a look. Page 8? No.
Paragraph 8 of the respondent's statement, page 21.
Ah, yes, you do say yes. Fair play, you do say it there, yes.
That's our position. And I hope we've been reasonably concise and clear on
Right,
other issues.
that's all right, that's right, yes.
I mean, it is looking at it online. It's just a repetition of quite a long definition section. Goes on forever.
Yes.
But
Well, if that's
I'm
what
puzzled as to why it says guidance at the top. We don't need to worry. It's there. So custodial sentence, if I scroll down through the C's, which there are quite a lot, means, as it says, a period of imprisonment not including a suspended sentence.
My lord, yes, I say that purely to address the discussion we had earlier on. I think last week, this
So
stage.
if that's right, then you're into whether or not it's serious harm, and that might depend on a lot of things, might it not?
My lord, yes. Now, in terms of depending on a lot of things, the first and foremost point is it does not appear that the specific point about harmful to the community was ever relied upon by the Secretary of State. The initial refusal of leave to remain as a graduate at page 164 of the core bundle. I'll drop the tabs because I appreciate my lord fully tabbed bundle.
164.
My lord, great.
So this is in the middle of an email thread.
So the Secretary of State serves decisions in a number of ways. Email is one such way. What my lord is looking at from the middle of that page is in fact the decision, the initial decision refusing leave to remain as a graduate. We can skip past pages 164 and 165. The substance of the reasoning is at 166.
I am therefore satisfied that you have been convicted of a criminal offence which has caused serious harm.
With no particularisation. Now, Judge Sheridan at paragraph 11 of his order did refer to the absence of reasoning when it comes to actual harm. So the same the appellant would say applies here, with no specific reference to harm to the community. That was the first decision in question. The Secretary of State then issued the administrative review decision, which is 148 of the core bundle.
148.
My lord, I'm grateful. 148. Again, served as part of an email. And the substance of that starts at 149, the reasons for decision.
It's often useful to look at the application for review, because if he doesn't refer to community in the application for review, you may not see something in the review. Do we have the application for review?
We do, my lord, so it's just a few pages there.
157, is it?
157 is the form itself,
Yeah.
dated the 8th of January.
161.
161 is where the grounds
Yeah.
begin. Now, these weren't drafted by my instructing solicitors. The
There's 4 and 5, is it?
yes, my lord, I think that's correct.
The applicant submits the words CSR are all English words which do not require gloss, although they must be understood in context. It is the nature of a criminal offence that it entails the causing of harm to an individual or to society of sufficient seriousness to justify the criminalisation of the behaviour. Yes.
And then going on to paragraph 7 as well, it just sets out the ordinary meaning of the word, ruling out.
And in paragraph 8, under the heading "Can serious harm be caused to a group or society in general?" What's that designed to address?
With respect to the author of this document, these seem significantly generic in the way that they've been drafted. The overarching position that I would take is neither the original decision nor the administrative review decision, both of which were decisions that Judge Sheridan would have been looking at, pin themselves to harm to the community.
Should we look at, having looked at, let's go back to the admin review decision, having looked at the request.
So we're back to 149, my lord.
Yes. I consider the points you raised.
Well, I should bring it with me next time. Well, I already do. Well thumbed. Thank you very much.
So
No
your point is it just reiterates the original decision.
My lord, yes, with no expansion or identification that harms the community was relied upon. For completeness and nothing more, I'll also draw attention to the pre-action response. Now, all that's said, this is within the supplementary bundle at pages 4 and 5. And in fact, perhaps again, just to assist the court, if we look at the pre-action letter itself, the substance of which starts in the supplementary bundle at page 11. And the arguments raised this time by SAJ Legal, who now come into the picture, paragraphs 7 to 10. On the absence of contact with an actual child in this case.
But this seems to be the argument on the merits. If it is, I've just looked at the rules say unless contrary intention applies, but assuming it is 9.4.1c, the argument would be, well, what does harm mean? And does it include setting out to have sex with a child, taking money to do that, having made a number of phone calls? Is that harm to society? It's creating a market for child sex. Didn't work this time, thank goodness. And you would say, no, that's not what it means. But that's precisely why, if you'd applied in time, you might have got permission. But at the moment, it seems to me that you're very seductively making your claim for judicial review.
To a degree, my lord, I of course have to, because we have to tread over the water that we say Judge Sheridan wrongly departed from. I'll come to the point in a moment, my lord.
Are you saying that there can be no circumstances in which an offence of this nature could come within 9.4.1.c?
No, my lord, but it's for the Secretary of State in those circumstances to identify why, especially when we're dealing with a decoy child.
On a claim for judicial review, they'll have to, yes.
Yes, indeed.
We haven't got there yet, but you're not saying cannot be within. Yeah.
And that requires a careful analysis of the factual matrix for the Secretary of State to conduct. All we have in the two decisions that Judge Sheridan was looking at is a bare assertion that the appellant has caused serious harm. What my lords will have noted is that there's no reference within that in itself to the fact that this was a decoy.
I mean, it's surely inconceivable. Is that too politically strong? In my view, it's inconceivable the judge wouldn't have been aware that it was a decoy child. Or are you saying are you saying that they weren't? The judge wasn't?
Not the judge. I direct that criticism to, my lord. I'm sorry if I wasn't clear on that. It's the Secretary of State.
Okay. Was the Secretary of State not aware it was a decoy child?
Aware of
Decision maker within the...
That may be for my learned friend to answer, but the two decisions which are the focus of Judge Sheridan's assessment are decisions in which there doesn't appear to be any real engagement with the factual matrix. That
Well, if that's the case, that would be your claim for judicial review, failed to have regard to a relevant consideration. But the judge says in paragraph 11, it could be argued, because he only ever interacted with an undercover police officer. He knew that that was the argument. And the contrary argument is that even if that's what you're doing, there's still the whole network. You're supporting a network. You're creating a marketplace for underage sex. And that can cause serious harm, depending on what serious harm means. So you could argue it either way. And he said, well, I see what you're saying, but arguable, but not that strong.
Well, my lord, insofar as can cause serious harm is concerned, we're aligned in our thoughts. From the appellant's submission, what is required is serious harm to have been caused. Now, perhaps if we can also at this point, having looked at the rules and looked at what was discussed between the appellant and the Secretary of State, turn to the guidance, which is, and I'll go straight to the page. This is the Supplementary Authorities Bundle. If my lords have tabs, it's tab 6, and it's page 68 where this guidance starts. So this is grounds for refusal of criminality. It's version 2, which was in force from 9th of November 2021. And serious harm, with specific reference to 9.4.1, is dealt with at page 97 onwards.
I was just going through it in order, yeah.
Yes.
Now, as my lords will see from the second substantive paragraph, the offence or an offence that has caused serious harm means an offence that has caused serious physical or psychological harm to a victim or victims, which Judge Sheridan said was an arguable error on the Secretary of State's part, or that has contributed to a widespread problem that causes serious harm to the community or to society in general. Now, my Lord Justice Lewis identifies that again, for want of a better term, feeding the operations that underlie the offence in this case are capable of doing so.
Yes.
That is about capability and about potential. There is also consideration to be had outside of this guidance about the appellant's intention, but the wording of the guidance is focused upon has contributed, which implies a past tense. And
Is a
also,
past tense.
It is a past tense, I'm sorry.
Mm.
It is a past tense, and also in my submission can only apply to an actual contribution.
Well, first of all, there's no qualification on the significance of the contribution, is there? So the qualifying words are widespread, which applies to the problem, and serious, which applies to the level of harm. So, do you contest the contention, Secretary of State's contention, which I assume she makes, that the problem of online abuse of children is A, widespread, and B, serious to punity. So you don't. So so the question is whether or not he has contributed, and if he's contributed in only a marginal way, then he's contributed, hasn't he?
There's no qualification within the guidance to the level of contribution. I accept that, my lord.
But your point is, if he embarks upon an act which, if it succeeded, would have been a contribution, your point is that it can only contribute if it actually succeeded in contributing. An attempt to contribute isn't a contribution. Is that
Yes,
your point?
indeed, my lord. And of course, being faithful to the facts of this case, the appellant's position is that the Secretary of State doesn't identify what contribution was, how that contribution is operated. The qualifications are, of course, to something that causes serious harm, which is, as the appellant say, there's no contest that activity of this kind is capable.
Well, I suppose the assertion you've got to meet is that any attempt to participate in this activity is a contribution to the widespread problem that causes serious harm, even if it's an unsuccessful attempt, because it's all part of the problem.
Well,
people are doing this. Any attempt to do it is a contribution, even if it's an attempt which could not succeed, because fortunately, the person on the end of the line was a police officer.
In my submission, there's a strongly arguable case against that, and of course I bring that back into what we say in terms of high satch, because that's what the judge was looking at. It's a past and actual contribution, not an attempted contribution.
Okay, it's a contribution which didn't succeed,
Yes.
but it was a contribution because it was because he was going online to do it. And what's the difference between, I mean, I'm not being flippant here, but what's the difference is, like Mr. Briggs this morning, he had a technical problem and he wasn't actually online when he that would be a that would be a contribution, wouldn't it?
That two points to make in respect to that, my lord. The first is, as the court has observed, that is a point for judicial review, and a point that the Upper Tribunal, we say, would need to grapple with if this appeal were to be allowed. But the conclusion that's reached by the Upper Tribunal is this is not a very strong case in circumstances where there's no attempt by the Secretary of State in writing to identify what the contribution was and how that falls within the guidance.
But why can't the tribunal make an evaluation for itself, just the way that I have?
The tribunal,
Obviously taking more time over it than I have in the few words I've just been putting to you.
whilst the tribunal is entitled to undertake its own assessment, it's an assessment that in this case has been undertaken with a context to refusing to admit an application on the basis that it's not very strong.
Yeah.
So another way of framing it is even the very strong threshold that HISAJ prescribes isn't one that requires the claimant, or the appellants now, to demonstrate that they would, without doubt, succeed on judicial review if leave were to be granted. Now, if contribution and the term contribution is considered in the wider way that, with respect to Lord Justice Walker identifies, it arguably takes the matter so far that any attempt, regardless of success or otherwise, falls squarely within the definition. Now that's an important point, which is capable, the appellants would say, of extending the guidance beyond what the word would suggest, with the Secretary of State having chosen to use the words has contributed in the past tense, where the guidance could quite readily and without difficulty have been termed in wider fashions.
Well, can I ask you about that? Because it goes on to sexual offences, and I understand that this was not referred to in the decision letters, but it might throw some meaning on what harm is concerned with, because these crimes cover everything from killing people through smuggling drugs to rape, and then you go on to sexual offences, and that deals with notification requirements, and that those apply if they're convicted of an offence and so on, and they're not insane. Details are recorded. That's monitoring the whereabouts of any sex offenders living in their community. Certain factors may also be the subject of the following: sexual harm prevention orders with the person who is convicted or cautioned for a sexual or violent offence. Now, I thought I'd seen somewhere, but you tell me I'm wrong, and I haven't gone back to the Act, that he would have to have been convicted of this offence, or would he have to sign on the sex offenders register? And secondly, I thought there was a sexual harm prevention order, or there was a reference to that.
There is a sexual harm prevention order, my lord.
That's aimed at making sure he doesn't do any more harm.
Yes.
And what about, is he on the sex offenders register?
I don't believe. I'm told no, and going back to the sentencing judge's remarks, although I stand to be corrected, and then takes a different view. Or I should say not the sentencing judge's remarks, but the notes of the sentencing judge's remarks.
Yeah.
And that was page.
We're back in the
Supplemental.
bundle at page 44.
I'm on page 46. Is that right? Is that where we should be, or is it earlier?
I think page 46 is correct, my lord, in respect to.
Sentence in the fourth paragraph. Notification requirement, 10 years. Barring regulations.
So he was required for 10 years to go on the sex offenders register.
Isn't that what notification means? Is that
Normally, yes. The point is we need to know. And then he can't work with any child groups and so on,
barring service?
because that's the barring service thing. And is there a reference to a sexual harm prevention order somewhere?
I have seen it, my lord, as part of my notes.
I thought I'd seen it somewhere, but increasingly it's hard for me to remember what day it is. And were there any conditions attached to the suspended sentence order? Because that very often gives you an indication of what the people were thinking at the time. Well, we just don't know, do we?
Actual formal record of sentence.
I mean, he must have the suspended sentence order, and he must have any requirement to notify. He must be able to tell us if he's the person that's subject to it.
46, my lord, is the 48. I'm so sorry. Is the
In the same bundle.
in
same
the same
bundle.
bundle? Yes, my
Oh,
lord.
there's the suspended sentence order, yeah. So he's got to complete it.
notification, does it?
It does refer to notification. It may be automatic. I just haven't looked at the statute for that. And there doesn't seem to be a reference to sexual harm prevention order, but that would have been applied for separately. And there'd be a separate order on that.
So you're making these submissions, just to remind ourselves, in the context of your amended ground 1, which you're seeking to argue that the judge's evaluation of this as arguable but not particularly strong was irrational.
My lord, yes.
So on that, can I just take you back to the guidance you were showing us, which is the sentence about contributing to a widespread problem that causes serious harm. So take a case where an offence has been committed which did not harm a victim because there was in fact a police officer rather than a victim. Would you accept that nevertheless that might have, in an appropriate case, contributed to a widespread problem that causes serious harm?
It's capable of having done so, and it would be remiss of me to exclude the possibility entirely.
And whether or not it has done would require investigation.
Yes.
So without much investigation, the judge here could not be satisfied that this was a very strong case.
Well, can I disagree on the ground, my lord, that the investigation would be required by the Secretary of State? It's for the Secretary of State to make a decision and for her to demonstrate that 9.41c is met in
Yes,
the
if you were in
circumstances.
time, but the burden's on you, isn't it, when you're applying out of time? You've got to establish the third head of the Denton test applied by analogy.
Well, the exercise that the judge undertakes at paragraph 11, and without further investigation, but just looking at the bare facts of this case that the judge was aware of, a decoy officer, a decoy child and an undercover officer, do not, in my submission, fall within the category that my lord identifies of an unsuccessful attempt that nonetheless does contribute. There will be crimes in those circumstances, but just looking at the bare bones of what the parties' arguments were, without going into any detailed investigation, there's no contact with the child, decoy child, undercover police officer. Those facts alone do not suggest that this wasn't a very strong case.
So attempting to do it, doing it, or thinking he's doing it, but in fact not doing it because there is no actual victim, you say is not a contribution.
On the facts of this case, my lord, no.
As known without further investigation, because that investigation hasn't taken place.
Yes, my lord. And that focus is purely on that factual matrix around what my lord has just identified, Lord Justice Baker, in terms of attempting to do it, but not in the presence of the child. Of course, more can be said around that, but if we stick to the parameters of High Sag and the facts of this case without delving into further investigation, then this could not, in my submission, rationally be excluded as a case that was arguable but not very strong.
Why do you say it? So you're saying it is irrational of him not to say it was strong.
Well, yes.
So what do you say is the strength of the argument?
The strength of the argument is perhaps to argue the case in the reverse, that none of the factors that were known to the judge, just from a reading of the pleadings and an understanding of the bare facts surrounding the offence in question, indicated that there had been a contribution of harm to the community.
That's because we don't know so much. And what we don't know is within your client's knowledge.
Actually, the contribution is not to the harm, it's to the problem.
Yes, exactly.
That's why I say it's on one reading, just a minimal, marginal contribution to the problem is what you're looking for.
But never in my submission identified or pleaded by the Secretary of State, not capable of jumping out from the facts of the case as they stand.
Well, didn't the judge have to do with the best he could with what he got?
And
What he got was that your client had made an attempt. and the mere attempt amounted to a contribution, obviously a marginal one, a nonetheless contribution to the problem, the widespread problem. We agree there's a problem, we agree it's widespread, we agree it causes serious harm. So, on one view, his evaluation of this argument as arguable but not particularly strong was, it could be said, given the paucity of information, the only one he could possibly come to.
Well,
You couldn't knock it out completely. Couldn't say it's not arguable.
well, in my submission, my lord, the appellants don't agree that the attempt has contributed to the problem, because we're not, on the facts as known, looking at a scenario where payment has been made, in which case there would have been a financial contribution to the problem. This, on the bare facts as presented, appears to be a case in which by fortune it did not get off the ground. And yes, I appreciate my lord's observations about him attending, him being arrested at the incident in question. But none of those factors point towards a contribution to the problem.
To me, a contribution has to, use your phrase, get off the ground.
Yes, my lord.
At
And
what point would it have gone off the ground?
payment. Payment
Payment.
would be one example, as my lord identified, because that would involve a financial contribution. Now, that's not an exclusive example, but the high point of the appellant's case is that nothing within the factual matrix presented to Judge Sheridan did get off the ground. Now, the paucity of information has been respected by the appellant's current solicitors who represented him at the judicial review stage, echoing the fact that this was not a rolling review and it wasn't open to the appellant to slide in further information that hadn't been put in by his representatives at the time that the applications were made. Now, having said that, the information that was before, one, the Secretary of State, and two, the judge, was adequate to find that there was a very strong case that the Secretary of State had not demonstrated that this fell within the guidance, because none of the factors are identified or capable of being identified. So I hope that clarifies the position that's taken on.
I think you've probably covered everything on that point.
May I then just very briefly deal with two authorities? Conscious I've gone slightly over what I would have
We've
estimated.
been interrupting you a lot. I'm sorry.
The two
You've been
authorities.
very helpful.
I'm grateful.
I think we've got some clarity now. Yes.
The two authorities that I'm about to introduce are not authorities that are directed to paragraph 9.4.1. They're directed to similar provisions under 117, which deal with serious harm. But they're important because they deal with the same terminology. And so for that reason, I'll take you to them. The first is this court's decision in the case of Mahmood. That, my lords, will find at page 70 of the authorities bundle.
Can we put away the other bundles for the moment, or these supplementary bundles?
Yes, indeed, my lord. I think these two authorities are likely to mark the end of my.
Yeah.
My learned friend makes his appearance in Mahmood in respect of appearing as counsel for the appellants. The case in question involved three separate foreign offenders who fell within Part 5A of the Immigration 2002 Act as being identified as foreign offenders for having caused serious harm. Mr. Mahmood's case is closest linked to that of the appellants before you. He, as the facts from paragraph 16 of the Court of Appeals judgment set out, had taken intimate photographs of himself and sent them to an actual minor child. And that's paragraph 16. Not only did he do that, he also facilitated the return of photographs from said minor. He received a 3-year non-custodial sentence. As paragraph 18
Where are you?
So this is paragraph 16 to
16.
18.
Yeah.
On account of failing to comply with the notice requirement and a breach of the
Oh, so I got 17, yeah.
we enter into an activated sentence and he got 6 months imprisonment on each count to run concurrently. The other two offenders in this appeal, Mr. Strenny at paragraph 22. Very briefly, this was a Malaysian national who was convicted for having used forced identity documents. And Mr. Kadir had a conviction for causing criminal damage.
Well, not using, actually being in possession of, and that's quite interesting, because if he doesn't use them, where's the harm? It's only when he produces them at the borders and thinks, oh yes, there's a nice British citizen, do come in. Because possession offences very often, that's why they say contribution to the problem. There's a market. Anyway, so he will have possession of false identity documents.
Now, for the purposes of my submissions, and in particular when referring to caused, etc., paragraph 39 at page 82.
We do need to know what the issue was that they were dealing with. So before we get to 39, can you show us what they were addressing their minds to the court?
The addressing of the minds in this case was to the sim phrase, which is the question of caused serious harm. And it's on that basis that paragraph 39
Okay,
these, of course, were also statutory appeals as opposed to judicial review cases. Paragraph 39 then goes on to identify in Lord Justice Simon's judgment that insofar as the word caused is concerned, harm must plainly be causatively linked to the offence. He then goes on to identify that the prevalence of even minor offending within the same paragraph may cause serious harm to society, but does not mean that an individual offence considered alone or in isolation has done so. And he gives the example of shoplifting.
Where do we see section 117D2 set out, paragraph 5? On page 77. Is that right?
Thank you. Yes.
Has been, yes.
you say it's the same wording as in the guidance
My lord, yes.
and the rule, you say?
Now, if I may draw your eyes back to page 82, G towards the bottom of that page, Lord Justice Simon can be recorded as saying, however, we agree with Mr. Biggs, at least to this extent, harm in this context does not include potential for harm or an intention to do harm.
Where is that?
G.
This is G, my lord,
82.
on page 82.
That's harm in the context of 117D, isn't it?
It is, my lord, that's
So
right.
the question is, was he convicted of an offence that has caused serious harm?
Do you mind reading on, Jay? Yes, next sentence.
Have I missed something out?
It does go on to say, as my learned friend invites me to do so, that so this is still G, where there is a conviction for a serious offence, it is likely...
Attempt offence.
It is likely that the sentence will be for more than 12 months. Fine, but that doesn't, in my submission, bring this below the very strong threshold that High Sergeant set out.
But he makes the same point that's made in the guidance about the possibility of harm to society more broadly within the same pattern.
My lord, yes. But again, the focus, as we say here, has to be on has contributed, and the absence of anything which would suggest that on the facts of this case that happened, even when one merely scratches the surface of the factual matrix.
But is there not a difference in contributing to the problem and causing the harm?
In this,
Causing the harm is a much more direct thing, whereas contributing to the problem is a broader categorisation, isn't it?
I'll accept.
Captures more people.
I'll accept that, my lord. But again, my submission stands, notwithstanding that clarification, that insofar as has contributed to the problem is concerned, that metrics doesn't demonstrate that there is anything.
Yes, I'm just wondering how this helps us. This authority helps us.
Insofar as it identifies that there must be a causative link, I think is the real high point of Mahmood insofar as...
But isn't the causative link required in Mahmood between the offence and the harm? Or am I missing something? Please don't feel shy and say if I am. That's 117D2 provides. Has he been convicted of an offence that has caused harm, serious harm? I mean, for myself, it can't be argued, if that was the test here, in our case, it couldn't be argued that Mr. Barot had caused, his offence had caused serious harm. That isn't the point, is it? Has he contributed to the problem?
Yes, that's right. And insofar as the first point is concerned, I think I'm is on the same page as Judge Sheridan, who observed the same point, that the actual harm hasn't been identified by the Secretary of State, nor we say has the contribution to the problem been identified.
Yeah.
I think my lords have the point.
Yeah. Was there one other case you wanted?
Just one question. The problem we've got here is you've got to look at Part 5A in total, and that deals with a number of things. One part of it deals with things that are applicable to all immigration decisions, including Article 8. Another provision, 177C, deals with a particular subset, the deportation of foreign criminals, and the definition is given for the definition of foreign criminal, which has got to be British citizen, 12 months and serious harm. So although the words are used, you do sometimes need to see the context. And it's very different. If somebody came from Ruritania and applied for an entry clearance and said, I've been convicted 4 times of trying to have sex with a minor, it's failed each time in Ruritania because the police are onto it immediately. But I would like to come to Britain, please. The Home Office may well be able to say, well, hold on a moment. What you're doing is coming to Britain and you're the person that has got this character, and we think that will or has caused serious harm in Ruritania, and if it happens here, it would contribute to the market here. The context is not letting people come in or removing their or not extending their indefinite leave rather than deportation. So
Yes,
it may be that phrase and these things need to be read in context.
Respectfully, my lord, the appellant's position would be that this is distinction without a difference.
It's the same, you say. Refusing leave and deporting somebody, you say it comes to the same effect. They can't be here.
It comes to the same effect in practice, and also when one looks at the structure of the rules that are used and compares them to 117C and D, we are in the territory of serious harm, persistent offending. There is a significant overlap in those circumstances between what one sees present within Part 9 of the rules as things stood at the time and 117D. So respectfully, the appellant's submission would be that is a distinction without a difference.
Anyway, you wanted to go to the other authority. Yeah?
The other authority briefly is then tab 18, which is again 117C authority. So this is 261, I'm sorry, of the authorities bundle.
Wilson.
Thank you. Now Wilson, just in terms of facts, was an individual convicted of an offence of possession of a bladed article in public. He breached a suspended sentence order. He got a 6-month sentence of imprisonment. possession of a bladed article, and 5 months to run consecutively for the breach of the suspended sentence. Neither of those cross the deportation 12-month threshold. At the first-tier tribunal, Judge Cape on that occasion concluded that this was not a case where his offending had caused serious harm. That part of the first-tier tribunal's reasoning was accepted by the Upper Tribunal. And I'll do no more at this stage than to rely upon the judicial headnote, which is also reflected at paragraph 53, but the judicial headnote is sufficient for my submission. It identifies within it, of course within the context of a statutory appeal, that the question of whether serious harm has been caused is a matter for an immigration judge to decide. Paragraph 2 is unsurprising. Consideration of all the relevant factors is required and outlines where a challenge to such a conclusion will lie. The relevant factors for causing serious harm are then set out at paragraph 3. 3D says that the burden is on the Secretary of State to show that an offence has caused serious harm. And 3G is important because it identifies that the mere potential for harm is irrelevant.
And H says that, yes.
And H, in my submission, again supports the position that Judge Sheridan is wrong. I'll also flag at this stage, if I may, paragraph 57 of the Upper Tribunal's judgment. This is at 281, where the judges found that there must be some evidence of actual harm caused.
Which paragraph, sorry?
57, my lord.
57, sorry.
And the global conclusion is at 58.
Well, if this is right, then your submission is that the guidance is misleading because the rules say serious harm, and serious harm can't involve the contribution to a serious or widespread problem.
The guidance is, of course, reflective of 9.41c, not 117d as it
Yeah,
stands.
but the words you said are the same, and what my suggested context was a difference without
Yes.
meaning. So you're looking at the words cause serious harm, and this judge seems to be saying that it can't be a contribution to a widespread problem. The fact that you're carrying knives, unless you actually do something with them, means it's not a problem, despite the fact that part of the problem in society is people carrying knives. That can't be right, can it? Unless the rule is that serious harm means actual serious harm, not contribution to a societal problem.
The focus that the judge puts at paragraph 58 is the risk of harm. And of course, the focus of the guidance is different, as my Honourable Justice Baker identifies when looking at the contribution.
Well,
to
there is a
harm.
disconnect, isn't there, between the seriousness of the contribution and the seriousness of the harm, because the contribution is to the problem. Unless I'm missing something, there is no causative link between what he does and the serious harm. The serious harm is caused by the problem. Isn't that how it's worded?
I think I may be being overly dim, but I don't.
Well, I may no.
Well, then,
Oh, you're
question.
just as likely that I'm being overly dim. In fact, more likely, I expect this is your area. Just draw what does this tell us? This authority, which is on the same lines as the mood, what does it tell us about the why do you say on the basis of this that the judge in our case went wrong?
The high point of both of these authorities from the appellant's submission is the need for there to have been an actual harm, and it's looking back as opposed to looking
Caused by
the offence in question. Yes. And it's that backward-looking assessment for an actual harm as opposed to intention or potential, as is ruled out by both Wilson and Mahmood, that we say causes the Secretary of State difficulty.
There has to be actual harm caused by the act of, for want of a neutral word, the act which led to the offence. Is that what you're saying?
Now, my lords, that does, in a roundabout way, bring me to the end of my submissions in respect of the ground in question. The overarching point is, as my lords have heard, is that we say that this wasn't a case that fell below the very strong threshold that High Sach had to, the appellants had to satisfy in order for the application for judicial review to be admitted. In those circumstances, we say that the judge's conclusions to the contrary were rational. I had proposed to then address the court on the question and the test to be applied when it comes to an application for judicial review that is filed out of time. But given the observations made by Lord Justice Lewis, which is that we are looking at this through the prism of, if I've understood my lord correctly, the relief from sanctions, but not necessarily applying it.
Well, they say by analogy, there's a few cases that say an application for an extension of time is not. I mean, High Sach, when you analyse it, doesn't say it is an application for relief from sanctions, but it says the same considerations apply. And there's another case that says, in any event, if you're looking at extension of time in the abstract, you'd consider the reasons, the significance of the delay, and all the circumstances.
Well, in light of that, my lord, perhaps if I can leave with two very short points. The first is to clarify the appellant's position is in alignment with that by saying that the appropriate test is one for an extension of time. And the second point, as I said at the outset, is regardless of where the court falls in respect of that debate, if there were one, the overarching position is that there is an indistinguishable link, or an indissoluble link, I should say, between the judge's decision to refuse to admit the application and his conclusions that this was a case where there had been harm to the community. And that, going back to the judge's order, is borne out by paragraph 11. Where the judge does look to the question of harm to the community, as opposed to contribution to a widespread problem that causes serious harm. So with that in mind, and given what we say is in fact a distinction between the test the judge applied in the order and what the guidance prescribed, even the low point of the appellant's case in these circumstances was one upon which this should have passed the High Sach threshold. I've gone well above what I expected to do in terms of addressing the court on time. So unless I can be of any further assistance, those are my submissions.
Thank you very much. Thank you very much, Mr. Biggs.
Thank you very much, my lord, my lords. Can I deal first with the two procedural issues that we need to grapple with? My learned friend's application for an extension of time to file the appellant's notice, and my learned friend's application for permission to amend the grounds of appeal. On the latter application, the Secretary of State is neutral. We acknowledge that there's no prejudice caused by the application to amend the grounds. They were filed in February of last year, and the Secretary of State has proceeded to deal with the issues on the basis of the grounds of appeal as amended. So I don't propose to say more about that application, unless there are any questions from my lords. On the application for an extension of time to file the appellant's notice, we do maintain the position in the respondent's statement, which is that relief from sanctions is necessary, or at least that the correct approach to the application for an extension of time is to look at the relief from sanctions principle.
Which is it? Because the two are different. The one is, this is you need an application for relief from sanctions under a particular rule. The other is, it is not an application for relief from sanctions, but the same principles apply. And there are cases which cover virtually everything except an application to make a claim for judicial review in the Upper Tribunal, and the Upper Tribunal, everything else is covered. So what is your submission? That there is a difference for an application to apply for judicial review? Or do you accept that all the cases are pointing in the direction you applied by analogy because of the importance of public law time limits?
Yes, my lord. Well, I'm dealing at the moment with the application for an extension of time to file the appellant's
But
notice.
it's the same thing.
And I'm entitled to point out that the Clark and Sayers case and Hysage and Yes Electrical, in my submission, take the position that there is an implied sanction that arises in circumstances where the time limit for filing a notice of appeal has been exceeded. And on that basis, the relief from sanctions principles are applicable.
You've got cases against you. You've got Hysage, you've got Amori in the Court of Appeal last year, which isn't referred to, and their applications to extend time for appealing.
I'm grateful.
Hysage is exactly this case, isn't it?
Yes, my lord. If Hysage, on its correct interpretation, held that you apply relief from sanctions principles, the Denton and White principles, by analogy, even in respect of an application for an extension of time to file an appellant's notice, then that's what Hysage decided. I would respectfully suggest that it doesn't matter greatly one way or the other. What matters is the relevant principles that are being applied, and Hysage is quite clear on any view that you apply the Denton and White principles when considering whether it's appropriate to extend time in respect of an application for permission to appeal filed late. It might be worth just looking at the Yes Electrical case on this. This is at page 43 of the authorities.
I'm not sure it's worth
Tab 7.
taking up much time on this. Part of the problem is we are having dozens of cases dealing with these fine distinctions. You do actually have a case Hysage which deals with Sayers and Clark and is binding on us. So what will we get out of Yes that is different?
Well, nothing, but it does summarise the position in my submission, so it may be of assistance in that way. It's paragraph 33 on page 51.
This is an application to allow an expert evidence.
Yes, so the conclusion in Yes was that that application is not governed by relief from sanction principles because there's no implied sanction, but the doctrine of implied sanction should also be limited, the court held in Yes, to cases where it's been established in the earlier authorities that it applies. And one of those cases in my submission is the case of an application for an extension of time in respect of an appellant's notice. You see that in paragraph 33 by reference to the Sayers decision.
But Sayers was considered in Hysage, and unless I'm wrong, and we'll have to go to Hysage, because otherwise we're going to have a case next week and the week after arguing precisely about this. Does Hysage, which considers Sayers, conclude that an application for relief from sanctions is necessary if you're applying outside the time limit for your appellant's notice to be considered, to put it neutrally?
I think the answer to that is best given by, I think it's Lord Justice Moore-Bick in Hysage judgment himself. It's paragraph 36 of that decision, which is at page 180.
We need 335 because the submission was they were free to hold that applications for extensions of time, the last sentence, should not be approached in the same way as applications for relief from sanctions. Yeah?
Yes, and that was on the basis that it was open to the court to effectively depart from the line of cases going back to Sayers. Now, of course, we have Sayers in the authorities bundle if my laws want to look at it. I'm conscious this is something of a tangential issue. Sayers is the font, if you like, of the law in respect of the concept of implied sanctions. And what we see at paragraph 36 is Lord Justice Moore-Bick saying that he's analysed the earlier authorities, and the conclusion is that in the light of those authorities, it's not open to the court to take a new approach to the approach taken in Sayers. as the authorities demonstrate, so Lord Justice Morbick explains, for the past 12 years it's been consistently understood that in the Sayers case, this court deliberately equated applications for extension of time, etc., with applications for relief from sanctions, because it's, in its view, the implied sanction of the loss of the right to pursue an appeal meant that the two were analogous. Now, that's the correct position, my lord.
Analogous. And
Yes.
you apply the principles.
Yes. I mean, the word equate.
Yeah. This isn't an application for relief from sanctions then. It's an application for extension of time where you have regard by analogy to those principles which are the significance of the breach, the reasons for the delay, and all the relevant circumstances.
Well,
And that's it, really, isn't
I'm
it?
content with that formulation, yes.
Yeah.
Great. I pointed out that in yes, it seems as though the court recognised that there was an implied sanction principle which should be confined to those cases, Sayers being the font of those cases, so it was held that there was an implied sanction. But the bottom line is that you apply relief from sanction principles by analogy where there's a so-called implied sanction, and yes makes it clear that new categories of implied sanction should not readily be identified.
All right. So that forgive me, but that's the approach. Do you want to make any submissions on the application of the approach, or do you leave that to us?
Very, very briefly, our position remains that set out in the respondent statement. So we say applying the three-stage ISAG.
Yeah.
There clearly has been a serious and significant failure to comply with the rules, bearing in mind the short time limit that's applicable for applying for permission to appear in this court from a decision refusing permission to apply for judicial review in the Upper Tribunal. There is, secondly, no good reason for the failure to comply with that requirement, and this is a point that my Lord Justice Lewis explored with my learned friend when he was making his submissions. The evidence that the appellant relies upon is wholly lacking in my submission, or at least is unsatisfactory, because it really doesn't adequately explain why steps were not taken sooner when they plainly could have been. These were appellants that were represented at the material time. They were, on the face of it, aware of the decision of the Upper Tribunal within the requisite period for bringing an appeal, and yet they effectively, with great respect to the appellants on this point, sat on their hands. And there's no adequate explanation as to why the firm representing them could not have taken steps to protect the appellant's position, which is plainly what a, with respect, competent firm of solicitors.
What do you mean by applying for a short extension in advance?
No, well, they.
Or filing something.
Yes, they should have provided prompt advice as to the need to bring an appeal within the appropriate time limit. Reading the evidence that is brief and that my learned friend took you to, I don't propose to go back to it. It's far from clear why the appellants decided to wait for the time that they did, if they received the advice that a competent solicitor would have given them, which is you need to act to protect your position.
Well, they should have gone immediately after the 31st and told them, and we don't know whether they did.
Exactly.
But when they said we want to ask questions, they should have been told, well, you can ask questions, but you've got to do that quickly. And the person you want to ask questions to isn't available. So if you want to ask questions, you lose your time.
Yes, that's exactly right, my lord. So we are entitled to make the point, we do make the point that there's no good reason for the failure to comply with the rules. Final category of issues, if you like, in terms of the HISAG three-stage test that's applicable, is the overall justice of the case, if I can put it like that. And there in my submission, there's not a huge amount going for the appellants. The reality is that the need to comply with procedural requirements must be given substantial weight. And there has been prejudice caused to the administration of justice by the procedural error in this case, or failure, I should say, in this case. There have been a number of applications, there have been a number of orders, and that has used valuable court resources and occasioned the parties to spend valuable resources dealing with those matters. So we invite the court to give substantial weight to those points. Unless I can assist further on that aspect of the issues.
Turning to the substance of the appeal.
I'm very grateful. And what I propose to do, my lords, is to deal in reverse order with the grounds of appeal. I acknowledge, as my learned friend I think accepted, that the grounds of appeal can be seen as two sides of the same coin. But I would respectfully suggest that it's sensible, dealing with that coin, to deal with what my learned friend has identified as the reverse side of it, ground 2 first. that makes the point. The grounds, the amended grounds, assuming we're going to
Yeah.
which I will to Bene essay, the amended grounds are at page 88 of the court.
Yes.
You will see that ground 2 makes the point that it was not open to the judge in the upper tribunal. This is 5.2. It was irrational, for the judge in the upper tribunal to refuse to admit the application for judicial review by looking to whether the claim he found to be arguable was also a strong one. So effectively the point that's being made there is it is irrelevant when considering whether to admit a late application for permission to apply for judicial review, whether or not the application, that the merits of the application are strong or very strong. The point that seems to be being made here is that you just look at whether there's an arguable case, and it's impermissible to go beyond that. Now, in my submission, that is plainly an unsustainable ground of appeal, because it is inconsistent with paragraph 46 and following of the Hysaj decision. Just to be clear, before we look at that part of Hysaj, I accept that when considering an application for an extension of time for bringing a claim or application for judicial review in the upper tribunal, you apply the relief from sanctions principles by analogy in the way that I discussed with my Lord Justice Lewis earlier. So what you do is you apply the Hysaj principles, albeit by analogy, because I accept that in the context of an application for an extension of time in respect of an application for permission to apply for judicial review, you're not in an established category of sanction. And certainly there's no express sanction. We do apply Hysaj, and my learned friend, as I understood his position earlier, accepts that. He concedes that that's the right approach. So that takes us then to paragraph 46 of Hysaj, which sets out the relevant guidance on how to approach the merits of an application for permission to apply for judicial review in the context of the time
Yeah.
The court will find paragraph 46 on page 183 of the authorities. And in my submission, the relevant test is between lines D and E on page 183 at paragraph 46. Only in those cases where the court can see without much investigation that the grounds of appeal are either very strong or very weak will the merits have a significant part to play, etc. And the rationale for that approach is then explained in paragraph 47 and 48. We don't need to look at that closely. In my submission, that is the approach the upper tribunal judge applied. As I think my learned friend my learned friend did accept that in opening.
Yes.
So that's
Well, he does. He says it's irrational.
Yeah, well, that's the end of ground 2.
Yeah.
That brings me to ground 1. Ground 1 is the point that the judge acted irrationally or was irrational to conclude that there was not a very strong case. That's, in my submission, the point
Exactly
made by
what he
ground-
said.
ground 1.
Should we go back to 11 just to see, make sure we got it precisely right? Paragraph 11 of the order.
Yeah, so just to be clear, the point I'm making here is that the question of whether or not the judge was right to conclude that there was not a strong case is the question raised by ground 1, not the question raised by ground 2.
Right.
So
Well, his actual finding is not just is a slightly longer wording the sentence beginning "in my view."
Yes. On
So
92.
it's a bit more than arguable but not strong, which is how it is sort of hyperlink at the bottom. It's arguable, as the respondent did not address in the decision the question of what harm the applicant caused in circumstances where this is not obvious, but his cause is not a particularly strong one, given that it is sufficient for there to be harm to a community or society in general. And on its face, the crime the applicant committed appears to be one that is, on any view, harmful to society. So that's what he decided.
Yes. And in my submission, that conclusion was one that was open to the Upper Tribunal. Because my learned friend's ground one claims that that conclusion was irrational. In my submission, that is a wholly unarguable, certainly correct submission. Just before we move away from the Upper Tribunal's reasoning, it's probably worth just bearing in mind that although the judge uses the expression particularly strong, not a particularly strong case, it is quite clear that he had in mind the test in HISAG. He specifically referred to HISAG at paragraph 6 on page 91. And as I pointed out, my learned friend accepts that the judge applied
He
effectively.
says it out of 92, doesn't he? Just above the bit he's just said.
He did. He recited it.
Very great. Yeah, I'm belaboring the point. I don't need to do that. So the submission is that it was open to the Upper Tribunal judge to conclude that this was not a particularly strong case or a very strong case, especially bearing in mind that requirement that the assessment of the merits applying paragraph 46 in HISAG is one that needs to be undertaken without much investigation.
What Mr. Guy says, defence to him, is that here the only fact you know is there was never a charge,
Yes.
and that's enough.
Yes.
For him to say, well, look, it's particularly strong here.
Yes.
There's nothing in the decisions to say harm to the community, nothing else that you could say, oh, hang on a moment, is this a societal problem? And therefore, he says it wasn't open to him at that stage to conclude that it wasn't particularly strong. That's his case.
That's my learned friend's case, and I'll meet that in a moment. But there was obviously the nature of the offence and the length of the sentence. It was a significant sentence, albeit that the judge chose to suspend the sentence. Now, in my submission, the guidance that my learned friend took you to sets out the correct test in this respect, in respect of whether there is serious harm caused by an offence to society.
So take us back to the guidance again.
Yeah, so this is the guidance in the supplementary bundle where we have a complete set of the guidance, supplementary authorities. The relevant part of it is under the heading serious harm on page 97. Page 97, supplementary authorities. So you have the if you like, explanation of the concept of serious harm, or an offence rather, that has caused serious harm, in the passage 3 paragraphs down underneath serious harm, heading serious harm on page 97, an offence that has caused, etc. I'd also invite my lords to note the passage that immediately follows, where a person has been convicted, etc. They will, including sexual offences, they will normally be considered to have been convicted of an offence that has caused serious harm.
Because the offence here is actually causing or facilitating.
Yes.
It's not actually...
That's right. It's not an attempt. And I'll come back to the significance of an offence being an attempt offence or not in a moment. But in my submission, this correctly states that the law, or to be more clear, the paragraph beginning an offence, etc., correctly states the law. The next passage is a Wensbury reasonable position for the Secretary of State to take in the light of the correct legal position. And I note that this guidance has not been challenged in these proceedings. So it's not open to my learned friend to make the contention that this is not an accurate statement of policy or a lawful statement of policy. That wasn't the point taken below. The other authority or materials that I'd like to take the court to in respect to the correct legal approach is paragraph 41 of the decision in Mahmood that my learned friend took you to towards the end of his submissions. So that's in the main bundle of authorities. It's tab 9, page 82 for the beginning of the report. The relevant passages are paragraphs 41 to 42. I'll also ask my lords to look at paragraphs 59 to 63 in a moment. Paragraph 41 begins on, I think, page 82. Forgive me, the authority begins at page 70 behind tab 9. Page 82 for paragraph 41. And my learned friend focused on a particular passage within paragraph 41, but I would invite my lords to consider the entirety of paragraph 41. What the Court of Appeal is doing at paragraph 41 is addressing the submission that I made that summarised it in the first sentence. Harm must be physical or psychological harm to an identifiable individual, that is identifiable and quantifiable. And that submission, I would suggest, is pretty close to, if not identical to, the point that I think my learned friend makes here. That submission was rejected for the reasons given in paragraph 41. In particular, the court explained that the criminal law is designed to prevent harm that may include psychological, emotional, or economic harm. And goes on to say there's no good reason to suppose a statutory intent to limit the harm to an individual. Some crimes, for example, supplying Class A drugs, money laundering, possession of firearms, cybercrimes, perjury, and perverting the course of public justice, may cause societal harm. And it's societal harm, in my submission, that we are dealing with in this case. In most cases, the nature of the harm will be apparent from the nature of the offence itself, the sentencing remarks, or from victim statements. And then you have the passage that my learned friend focused on. And then finally, the sentence that I asked my learned friend to read. Where there is a conviction for a serious attempt offence, it is likely that the sentence will be more than 12 months. So the point that's being made there is that the length of sentence informs the serious harm question, or can do. And it's acknowledged, albeit implicitly, that an attempt offence can be an offence that causes serious harm. And that, in my submission, must be because such an offence causes societal harm.
Is this the point about it in the guidance, the contribution to the widespread problem?
Yes.
Or is that not quite the point you're making?
No, that is the point. The point I'm making is that the guidance is consistent with this passage in Mahmood.
Yes.
The idea of societal harm is harm being caused by a particular offence to wider society. But of course, that sort of harm is only ever going to be contributed to by a particular offence. It's not going to be caused exclusively by or wholly by a particular offence because of the nature of the harm. It's societal harm. And so what the guidance is seeking to do in my submission, the passage of the guidance that I submitted earlier was an accurate statement of the law, is seeking to explain how that works.
There are different things, though. I mean, there's harm to society where there's not an identifiable victim. People talk about victimless crimes like white-collar crime and so on, or things like that. But
Yes.
there's still a harm to society, and there's sometimes a financial harm to society. There's other things like sexual crimes, solicitation of prostitutes, and so on, where the harm is slightly different. It's simply that it feeds the market or it contributes towards a problem.
Yes. Well, if we go back to paragraph 41, I think my Lord's observations are entirely consistent with the examples of crimes that cause societal harm
Yes.
that the court gives. One of those, an additional example I would firmly submit is an offence of the type that was committed here. Encouraging or inciting a minor to engage in penetrative sex.
A good example is possession of a bladed article, because in parts of London, lots of people carry bladed articles. They say it's self-defence. It's not a defence in law,
Yes.
and they might not have used it, but it's the creation of a knife culture or a gun culture, or sexual market in children, you would say, I imagine.
I respect.
It's the widespread problem that causes
Yeah.
the serious harm to society.
Yeah, yes.
The contribution will inevitably be, you say, only a small, and my phrase, marginal contribution,
Yes.
because in the big picture, it's only ever one small incident in a bigger picture.
Yes.
But, yeah.
That's the point.
And that's why you have policemen at the end of websites telling
precisely.
people that they're not a 6'6" hockey player, but they're a 14-year-old girl. It's
So-
to try and stop them getting at the girls
That's right.
or the boys.
Of course, my lord. And so in this case, this offence was an offence that caused societal harm in my submission, and it was certainly open to Upper Tribunal Judge Sheridan to conclude that that appeared to be the position without much investigation of the merits. Now, as my Lord Justice Lewis points out, that is because this appellant, or the first appellant I should say, engaged in a market that constitutes a very serious problem, a market for the sexual exploitation of minor children. And it doesn't diminish his contribution to that problem or that market, or his engagement in that market, that he didn't go through with the transaction and pay over the £100 because
He did go
thankfully...
through with it, but he couldn't find a willing
That's right.
victim because he actually went there with the money in his pocket. And sometimes they don't do that. Sometimes they say, I can't go through with it, and that's a different
Yes.
and even less reprehensible scenario. Yes.
Yes. So there was a contribution to the market, even though the transaction didn't complete, if you like, and even though, thankfully, there was no specific victim in this case.
The confusion may come because of the shorthand use of the phrase "an offence that causes serious harm."
Yes, it's a compressed statement, but it has been worked through, albeit in the context of Section 117D, and I appreciate that's a different context. I certainly acknowledge that. In the Mahmood case, and my submission is that paragraph 41 is really the working through of how societal harm can be relevant to the concept of causing an offence causing serious harm. And I've made my submissions on that. Now, my learned friend, just for completeness, relies on the Upper Tribunal's decision in Wilson. Just a couple of points to note in respect of Wilson. Firstly, this is a case looking at the application of Part 5A and Section 117C, not the specific immigration rules we're dealing with. Secondly, this is a case that was concerned with a decision of the first-tier tribunal that was being challenged on appeal, not with a decision of the Secretary of State. And the relevance of that distinction is that it, in a judicial review challenging a decision of the Secretary of State, such as the decision that my learned friend seeks permission to challenge by way of his client's application for judicial review, Wednesbury principles are applicable. So it's for the Secretary of State to form a view about whether an offence caused serious harm to society. And that assessment can only be interfered with on well-established public law principles. When the question of serious harm in the context of Section 117D and Section 117C comes before the first-tier tribunal, the first-tier tribunal has to itself form its own assessment. And it's that latter context that the observations in Wilson are set out against. But in my submission, There's nothing in Wilson that is contrary to the points that I've made already as to how societal harm can be relevant here. My learned friend relies on the list of factors at paragraph 53, but those factors are specifically meant to reflect the decision in Mahmood. And as I've sought to explain to my lords, Mahmood is entirely consistent, by reference to Mahmood at paragraph 41, Mahmood is entirely consistent with the Upper Tribunal's decision in this case.
Well, is H consistent with Mahmood?
I'm sorry, my lord.
Is H 53H the fact that a particular type of offence contributes to a serious widespread problem is not sufficient?
Yes.
There must be some evidence that the actual offence is considered. Is that consistent?
I recognise the potential tension there. The submission is, insofar as H is not consistent with Mahmood, Wilson must be wrong. Mahmood was binding on the Upper Tribunal with respect. In terms of section 117D and the relevant definition, it's also binding on this court.
Well, it might be said that you've still got to look at the individual offence, because H is outlawing just because it's a particular type of offence.
Yes.
But you can still look at what was done in the actual circumstances with further investigation and decide, well, in this case, it was something which contributed to that wider problem.
Yes, I agree with that, Lord. The point I was making a moment ago was intended to be a contingent point. If and insofar as H is inconsistent with Mahmood, it doesn't need to trouble my lords because Mahmood sets out the correct law. But in my submission, looking at H carefully and in context, it can be reconciled with Mahmood. What's being said there, albeit perhaps not as clearly as one might hope, with great respect, is that you need to have a particular offence. You can't just look at the type of offence and not look at the specific offending in a given case. That doesn't assist my learned friend in any way. And you can see that actually from the second clause of the paragraph. There must be some evidence that the actual offence has caused serious harm. And F is consistent with paragraph 41 of Mahmood, where it doesn't specifically look at societal harm.
So we should read H saying there must be some evidence that the actual offence has contributed to a serious widespread problem.
Yes. So it's not that there are offences that seek to deal with a widespread problem or harm that causes harm to society. There has to be a specific offence. And in my submission, that's trite, but it doesn't assist my learned friend's case because there was a very serious specific offence in this case that the Upper Tribunal Judge Sheridan, whose decision is sought to be appealed in this case, properly identified as one that, on the face of it, would cause serious harm to society in a way that was consistent with that expression of the principle in the policy.
Yeah.
And Mahmood.
Thank you.
So for those reasons, there is absolutely nothing to ground upon. For the sake of completeness, we are at the stage of a rolled up hearing. We do submit that my learned friend's appeal is not properly arguable with a realistic prospect of success, so we do invite my lords to refuse permission to appeal. But if my lords are persuaded to grant permission to appeal my submission, the appeal must be dismissed for the reasons I've given.
Thank
But
you.
hold on, that puts together a lot of things. The only thing that we're deciding, ultimately, if we grant permission and extend time, the appeal is on not extending time. If we allow the appeal, time should have been extended. So the claims within time and the actual underlying judicial review claim has got to be remitted back to the Upper Tribunal to be decided. We're not deciding whether or not he wins or loses. We're deciding whether or not he is entitled to have a go at winning. That's correct, isn't
I
it?
agree with that, my lord.
Yeah.
Yes, the submission I just made was about the was about whether or not to allow the appeal.
You say, first of all, refuse permission. Secondly, if you grant permission, refuse the appeal.
Yes.
Thirdly, you accept my lord's point that if you allow permission, if we allow the appeal, having granted permission, it should be remitted.
Yes, I hadn't addressed remedy, which I think my lord's point goes to.
Just so everyone knows what we're actually doing.
Yes, I agree with the proposed remedy that my lord identifies.
If they win on the other three. Yeah.
If my learned friend wins, which for the reason should not.
Yeah.
Okay. Thank you very much, Mr. Biggs. Now, Mr. Gager, can you deal with this fairly in the next 5 minutes?
I deal with it in a few sentences, my lord, so yes, indeed. First of all, if I can echo my learned friend's position on the matter of the metal, I agree with Lord Justice Lewis that if the appellant were to succeed, the judicial review application should be remitted back.
Agree disposal summary.
My lord, yes, I'm
Yes.
grateful. For the risk of then stating the obvious, you were taken to the guidance at page 97 of the supplementary authorities bundle.
We got it.
The only point I'd make in respect of that is to emphasise that the paragraph that says that an offence may have caused serious harm, even if the punishment imposed. Dealing with sexual offences, so this is just above the sexual offences heading. It deals with sexual offences in a normally leads to an application being refused circumstances. It doesn't mean that an offence that involves sexual harm must of itself involve an application being refused for that reason.
Yeah.
My learned friend then took the court through Wilson and said that the distinction between Wilson and this case is that Wilson was a statutory appeal. And again, I've used the phrase earlier on in my submissions, the appellant would say that is a distinction without a difference. Wilson, because of its nature as a statutory appeal, placed the powers of decision making in the court of an immigration judge, but the principles that apply to the test of serious harm are capable of being carried over to decisions made squarely by the Secretary of State. And the final point I'd make in that respect is that paragraph H of Wilson, as I think my Lord Justice Baker said at the end of my learned friend's submissions, is one that does require the question of the actual offence and the actual offending to have caused contribution as opposed to a more general position. And it appears in some respects, as I said at the end of my earlier submissions, that it's not quite the question that Upper Tribunal Judge Sheridan asked himself at paragraph 11 of his order, because instead of looking, as the guidance prescribes, to whether the applicant's offence had caused and contributed to a wider problem, the judge looks instead at the offence having caused harm to society, which is a different question. Those are my submissions, unless I can assist the heaven before the judge.
Thank you very much, Mr. Gager. Well, that's very efficient of you all, all. We're going to reserve our judgment in this case. As you know, that means in due course you will get a draft judgment so that you can correct any errors, minor factual errors or typographical errors. Obviously not an opportunity to re-argue the case. Once we've had your corrections back, we will arrange for the judgment to be handed down. No need for the parties to attend. It will be done electronically in the usual way now followed. We'd be grateful if on receiving our draft, you would prepare a draft order that reflects our decisions insofar as there are any issues between you on any ancillary matters. Please can we have short written submissions which we will resolve on paper. Thank you both very much. Thank you all very much for your assistance with this